Explanation of Article 311 of the Indian Constitution. Location in the Constitution. Part 14, Services under the Union and the States. Chapter 1, Services. Purpose of Article 311. Article 311 provides safeguards to civil servants against arbitrary dismissal, removal, or reduction in rank by the government. It ensures job security for government employees and protects them from unfair actions by the executive. Key provisions of Article 311. Clause 1. Authority to dismiss or remove. A civil servant cannot be dismissed, removed, or reduced in rank by an authority lower than the one that appointed them. Example: if a civil servant was appointed by a state public service commission, then only an authority of equal or higher rank can dismiss them, not a subordinate officer. Clause 2. Inquiry and right to be heard. A government employee cannot be dismissed, removed, or demoted without a proper inquiry. The inquiry must follow natural justice principles, meaning the employee must be informed of the charges against them. The employee must be given a reasonable opportunity to defend themselves. Exception: if the penalty is decided after an inquiry, the employee does not need a separate opportunity to argue about the severity of the punishment. Exceptions, provisos to Clause 2. There are 3 exceptions where an inquiry is not required before dismissal, removal, or reduction in rank. A. Criminal conviction. If the employee has been convicted of a criminal offense, they can be dismissed without an inquiry. Example: if a government servant is convicted of corruption or fraud by a court, they can be dismissed immediately. B. Impracticality of holding an inquiry. If the disciplinary authority believes that holding an inquiry is impractical, it can dismiss the employee without an inquiry. Example: if an employee has absconded or is creating serious disturbances in the department, an inquiry may not be possible. The reason for not holding an inquiry must be recorded in writing. C. National security concerns. If the President or Governor believes that holding an inquiry would be against the security of the state, they can dismiss an employee without an inquiry. Example: if a civil servant is suspected of espionage or anti-national activities, an inquiry can be skipped. Clause 3. Finality of the decision. If a question arises about whether it is reasonably practicable to hold an inquiry, under exception B, the decision of the dismissing authority is final. Example: if a government department declares that an inquiry is not possible due to an employee fleeing abroad, the courts generally cannot question this decision. Analysis of Article 311. How it protects civil servants. Prevents arbitrary dismissal by ensuring due process. Mandates an inquiry before dismissal, except in specific cases. Ensures that only the appointing authority or higher can dismiss an employee. Limitations on government power. The government cannot fire employees at will, unlike in private jobs. Even under Doctrine of Pleasure, Article 310, Article 311 acts as a safeguard. Judicial interpretation. The Supreme Court has ruled that Article 311 protects only permanent civil servants and not contract employees, casual temporary employees, ad hoc employees. Comparison: Article 310 versus Article 311. Aspect: Article 310, Doctrine of Pleasure, Article 311, Job protection. Who holds power? President, for Union, and Governor, for states. The appointing authority must follow due process. Can employees be removed at will? Yes, but subject to Article 311. No, an inquiry is required except in special cases. Are protections available? No. Yes, except in cases of criminal conviction, impracticality, or national security. Conclusion. Article 311 provides constitutional safeguards to civil servants, ensuring fair treatment before dismissal, removal, or demotion. However, it allows exceptions in cases of criminal convictions, impracticality of inquiry, or security concerns. It balances the government's authority with employee rights, preventing arbitrary dismissals. The Constitution of India. Part 14. Services under the Union and the States. Chapter 1. Services. Article 311. Dismissal, removal or reduction in rank of persons employed in civil capacities under the Union or a state. 1. No person who is a member of a civil service of the Union or an All India service or a civil service of a state or holds a civil post under the Union or a state shall be dismissed or removed by an authority subordinate to that by which he was appointed. 2. No such person as aforesaid shall be dismissed or removed or reduced in rank except after an inquiry in which he has been informed of the charges against him and given a reasonable opportunity of being heard in respect of those charges. Provided that where it is proposed after such inquiry to impose upon him any such penalty may be imposed on the basis of the evidence adduced during such inquiry, and it shall not be necessary to give such person any opportunity of making representation on the penalty proposed, provided further that this clause shall not apply. A. Where a person is dismissed or removed or reduced in rank on the ground of conduct which has led to his conviction on a criminal charge, or B. Where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reason, to be recorded by that authority in writing, it is not reasonably practicable to hold such inquiry, or C. Where the President or the Governor, as the case may be, is satisfied that in the interest of the security of the state it is not expedient to hold such inquiry. 3. If, in respect of any such person as aforesaid, a question arises whether it is reasonably practicable to hold such inquiry as is referred to in clause 2, the decision thereon of the authority empowered to dismiss or remove such person or to reduce him in rank shall be final.